HR professional, if your managers are conducting any interviews this week, stop. There are 5 questions that seem harmless but trigger instant EEOC liability. I've seen these exact questions cost companies $80,000 in settlements, and they're being asked in interview rooms right now. Here's what your hiring managers don't realize about pre-employment screening. I'm Alex Castro, a Florida licensed labor and employment attorney with AXC Legal, located in Fort Lauderdale, Florida. I help South Florida businesses build compliant hiring processes and defend against EEOC charges that start in the interview room. Remember, this is general information only, not legal advice. Every employment situation is unique and requires individualized evaluation. You probably think your interview training is solid. You've told managers to stick to job-related questions. You've got approved interview guides. You've done harassment prevention training. Your process feels legally protected, and most HR teams have similar protocols in place. But here's what the EEOC sees differently. Managers asking the wrong questions, even with good intentions, creates discrimination lawsuits. According to EEOC enforcement guidance, seemingly innocent questions about availability, family planning, or health conditions violate federal discrimination laws. This HR practice looks like thorough candidate screening, but actually creates liability that plaintiffs' attorneys search for in every discrimination case. Even experienced HR teams can miss hidden traps buried in conversational interview questions. Today, I'll show you the 5 most dangerous interview questions your managers are probably asking about right now, and exactly how to replace them with legally compliant alternatives before they trigger 6-figure EEOC charges. Your manager is interviewing a strong female candidate. The position requires occasional evening meetings or weekend work. The manager asks, do you have young children at home? Or what are your childcare arrangements? Or will your family obligations interfere with the job schedule? The manager thinks they're being practical. They want to make sure the candidate can actually do the job and be available when needed. The question feels reasonable because it's about whether someone can work the required hours. Most managers, they would ask the same thing. But here's what employment attorneys know that HR may not know. Questions about childcare, family status, or parenting can be considered sex discrimination because they almost always get asked to women and not to men. The EEOC looks at patterns. If your managers ask women about childcare but don't ask men the same questions, that's illegal discrimination. If they ask everyone but only reject female candidates based on the answers, that's also illegal discrimination. Smart HR departments know well-intentioned questions become evidence against you in court. According to EEOC data, sex discrimination claims based on family status or caregiver questions settle between $45,000 and $85,000. Court records show these claims win when female candidates can prove they were asked about childcare while male candidates weren't, or when the employer can't prove the question was actually necessary for the job. Here's how it plays out. Manager interviews 12 candidates, asks 8 female candidates about childcare arrangements, asks 0 male candidates the same question, hires a male candidate. 1 rejected female candidate files an EEOC complaint pointing to the interview question as proof of sex discrimination. The company's own interview notes become the best evidence against them. Here's the checklist I give every HR team before managers conduct interviews. First, train managers to ask about schedule availability without mentioning family. The right way to ask, this position requires occasional evening meetings and weekend work. Are you able to meet this schedule? Second, require managers to ask the exact same availability questions to every single candidate. Male, female, young, old, everyone. Third, write down the job-related reason for any scheduling requirements in the job description before interviews even start. Fourth, review interview notes immediately after each interview. If you see any mention of family, children, spouse, or childcare, flag it right away and document that the question didn't affect your hiring decision. Fifth, create a standardized interview script with pre-approved questions that every manager must follow. If they want to go off script, they need HR approval first. That protects you from childcare discrimination, but without this next protocol, you're still exposed to pregnancy discrimination claims that cost even more. Your manager is interviewing a candidate who could have children. The position requires a big training investment or long-term commitment. The manager asks, are you planning to start a family soon? Or do you plan to have children? Or even, are you pregnant? The manager thinks they're protecting the company's training investment. They want someone who'll stick around. The question feels like smart business planning. But here's what catches even experienced HR teams off guard. Questions about pregnancy or family planning are automatically illegal. There's no situation where these questions are okay to ask. None. The EEOC specifically says it is discriminatory to ask about pregnancy or family plans during interviews. Courts have ruled that these questions are basically proof you were discriminating, at least in some ways, even if you end up hiring the person anyway. According to EEOC data, pregnancy discrimination claims based on interview questions settle between $60,000 and $100,000 because the violation is so obvious. There's just no gray area. Asking about pregnancy or family planning is a surefire way to pick up an EEOC charge. The problem gets worse when managers write these questions down. I've seen interview notes that actually say, asked about family plans, Candidate said not planning children soon, good for long-term role. That written note becomes almost impossible to defend in front of the EEOC. Here's the protocol I recommend to every HR department. First, make it crystal clear in training that questions about pregnancy, family planning, or having children are completely off limits. Make violating this rule a fireable offense for managers. It is such an obvious path to legal liability that the penalty needs to match the seriousness of it. Second, if you're worried about retention, ask job-related questions instead, like, this position requires a 3-year project commitment. Are you interested in this type of long-term role? Third, if a candidate brings up their pregnancy on their own, train managers to redirect the conversation. We're excited about your qualifications for your role. Let's focus on the job requirements and how your skills match our needs. It's one thing for the candidate to volunteer the information. It's another for the interviewer to be too interested in the topic. Fourth, never write down anything about pregnancy or family planning in interview notes, even if the candidate volunteers the information. You're just creating a record that it might have mattered in the evaluation. Fifth, if a manager asks these questions despite your training, document that you corrected them immediately and make sure that manager doesn't get to participate in the final hiring decision for that candidate. Now your family status questions are eliminated, but there's still a hidden trigger in health-related questions that plaintiff's attorneys specifically look for. You've got a manager that notices a candidate using a cane, has a speech pattern that might indicate a condition, or mentions taking medical leave at their last job. So the manager asks, do you have any health conditions we should know about? Or, will you need any accommodations? Or, how many sick days did you use at your last job? The manager thinks they're being helpful by planning ahead for accommodations. They want to make sure the candidate can actually do the job. The question feels like responsible planning. But here's what the EEOC sees that catches most HR teams off guard. Under the Americans with Disabilities Act, the ADA, you absolutely cannot ask health-related or disability questions before you make a job offer in virtually all scenarios. This is a hard rule with almost no exceptions. It doesn't matter what you intended. The question itself is almost always a fast pass to liability. EEOC data shows disability discrimination claims based on asking medical questions too early settle between $55,000 and $90,000. These cases are especially expensive because the ADA allows extra damages on top of just the lost wages. The violation gets worse when you don't hire the candidate. Even if you rejected them for totally legitimate reasons, asking the medical question before the offer makes it look like you discriminated. The burden then falls on you to prove the disability wasn't part of your decision, and legal fees, they're not cheap. Here's a system I give every HR team to avoid ADA violations. First, train managers that all medical and health questions are completely prohibited until after you make a job offer. No exceptions, even if the candidate brings it up first. Second, there's only one compliant question you can ask before making an offer. Can you perform the essential functions of this job with or without reasonable accommodation? Ideally, you'll also have given them a written list of what those essential functions are. Third, if a candidate tells you about a disability or accommodation need before you make an offer, managers should acknowledge it professionally but not ask follow-up questions. We appreciate you sharing that. We'll discuss accommodation needs and options later in the process. Fourth, you can only ask about accommodation needs after making a job offer, and document that you made the offer before any medical discussions happened. Fifth, never ask about sick leave history, workers' comp claims, or past medical conditions at any point in the early interview pre-offer process. If you need to know about attendance, ask, this position requires regular attendance during certain hours. Can you meet this requirement? Your disability questions are compliant now, but there are 2 more questions that trigger instant EEOC liability that most managers don't even realize are illegal. Your manager is interviewing someone who looks like they're in their 50s or 60s. The manager asks, what year did you graduate high school? Or, when do you plan to retire? Or, are you comfortable working with younger supervisors? Or even, how old are you? The manager thinks they're figuring out culture fit or long-term commitment. They want someone who will stay in the role. The question feels like normal human conversation. But under the Age Discrimination and Employment Act, which protects anyone 40 or older, any questions designed to figure out a candidate's age can be illegal discrimination. According to the EEOC, this includes sneaky ways of asking about age like graduation years or retirement plans or calling someone overqualified. Here's how courts look at these cases. If the candidate can show you asked the question and then didn't hire them, you now have to prove age wasn't part of your decision, which becomes almost impossible when age-related questions show up in your interview notes. According to EEOC data, age discrimination claims based on interview questions settle between $50,000 and $80,000. Here's what protects you. First, train managers never to ask about graduation dates, age, retirement plans, or use phrases like overqualified or looking for someone younger. Second, if you want to know about commitment, ask, this is a long-term position with growth opportunities. Are you interested in a longer-term role? Third, remove all age-related information from applications and resumes before managers see them. Black out graduation years and dates. And here's the 5th question that's costing companies thousands. Your manager notices a candidate wears religious clothing or mentions attending religious services when talking about schedule flexibility. The manager asks, "What religion are you?" Or, "Will your religious practices interfere with work?" Or, "Can you work on Sundays despite your faith?" The manager thinks they're addressing legitimate scheduling concerns. They want to make sure the person can work when needed. But under federal law, you shouldn't ask about religious beliefs, practices, or which religion someone belongs to during interviews. The better legal approach is to describe the job schedule requirements and ask if the candidate can meet them without any mention of religion. According to EEOC data, religious discrimination claims settle in similar ranges as the other violations, between $50,000 and $80,000. The problem gets exponentially worse when you document these questions or when multiple rejected candidates file complaints citing the same questions from your managers. Here's what triggers major investigations. Multiple candidates report being asked about their religion, none get hired. The company's interview notes reference not a good fit or concerned about availability. The EEOC opens an investigation into your entire hiring process now. Here's the protocol. First, train managers never to ask about religion, religious practices, or religious holidays. Second, describe schedule requirements without asking about religion. This position requires Sunday availability. Can you meet this schedule? Third, if a candidate brings up religious accommodation needs, note the request without discussing their religious beliefs. We'll address accommodation requests after extending an offer. Fourth, never write down religious affiliation, practices, or clothing in interview notes. It suggests they matter to you. Fifth, for both age and religion questions, conduct spot checks of manager interview notes after each hiring cycle to catch prohibited questions before they become evidence of a pattern. Sixth, consider using interview panels where HR is present to stop prohibited questions in real time. Remember, childcare questions open you to $45,000 sex discrimination claims. Pregnancy questions could trigger $60,000 in clear-cut violations. Asking about disabilities before making an offer could create $55,000 plus in ADA liability. Age-related questions could cost $50,000 plus per EEOC charge. And religious questions settle in the same range according to published enforcement data. Here's the math that matters. Comprehensive interview training and compliance reviews typically cost $3,000 to $5,000 per year. The average discrimination settlement, according to EEOC statistics, ranges from $50,000 to $85,000. One manager asking the wrong question costs more than 10 years of prevention training. The math, it just isn't even close. This is exactly what I review for HR departments before EEOC charges arrive. Because fixing these problems after a discrimination complaint costs 50 times more than preventing them. HR professional, you are the front line when it comes to protecting your company from interview-based discrimination claims. Even the most experienced managers can miss hidden traps buried in conversational questions that feel job-related but create instant liability. If your managers are conducting interviews right now, especially without standardized interview scripts or real-time HR oversight, getting a hiring practices review could be the difference between a compliant process and an $80,000 EEOC charge. A proper interview compliance audit can bring you peace of mind, protect your company's reputation, and reinforce the excellent work your HR team is already doing. If you're unsure about your current interview protocols or manager training program, you may want to consult with a qualified employment attorney who can evaluate your specific hiring procedures. The link to schedule a hiring practices review is in the description below. Let's make sure your interview process follows federal regulations, supports your team, and protects your business from preventable discrimination claims. Thanks for watching, and thank you for doing the hard work of building compliant, people-first workplaces.